Alright, this library lawsuit about being banned for life is looking like a loser lawsuit to me. The way that the library is arguing here. They want to call it the Natchitoches parish government, but it's the library. They could call it also the Natchitoches police jury. It's interchangeable. So the library responds, and this is how they responded. Let me quickly just scroll through. I'm showing all this information. I actually got it copied and saved. This is how it looked when I got it. But I had ChatGPT open it up, or just save the... Okay, alright, that was that. This is their response. I had a summary. Let's do the summary. Okay, and then it's the original is in yellow. So the summary of it, a ChatGPT summary. Let's see. Defendant argues, or the library. I should have told ChatGPT to call the defendant the library. The library argues Mr. Hines filed this claim too late, well beyond the legal time limits for filing. The 1-year prescription period for tort claims applies to Mr. Hines' case since his claim arose back in 2022 before that law change amendment extending this period to 2 years. Even under the 2-year prescription, his claims would still be untimely as they were filed 2 years and 6 months later. The open meetings law claims also fail because they must be filed within 60 days of the violation, which I exceeded. My tort claims, I claim for defamation and intentional infliction of emotional distress, are subject to 1-year prescription under 3492, and it's updated in 2022. The law's amendment to extend the period to 2 years is not retroactive. Since I did not file within 1 year of getting banned, my claims are time barred. So I should be able to let me just continue. The burden of proof to show the claims are not prescribed falls on me, and I have not met this burden. I conflate deterrence conduct with damages. I assert that prescription begins when the tort occurs and not when the damages are realized. Okay. Yeah, that's an argument that they're going to just say I filed a tort and I didn't file for recurring damages in my original lawsuit. So they're just going to say, oh, because I filed a tort, it doesn't apply, so my lawsuit's no good. Mr. Hines' argument that the continuing harm doctrine applies is rejected because the library issued the ban notice only once and no continuous harm occurred. Oh, so if I just go back there and there's not going to be any harm done to me, right? It's crazy for them to be able to argue like this. The defendant cites Crump v. Sabine River Authority to explain that prescription applies from the date of the initial action, not from the ongoing consequences like damages. On the defendant's the library. The library cites Crump v. Sabine to explain that prescription applies from the date of the initial action. Open meetings claim, they fail. The library points out that Mr. Hines' citation of Rogers is inaccurate and appears to reference a non-existent case. The library suggests that repeated miscitations could lead to sanctions. Now, isn't that something? I get kicked out of the library for life, and they also want to turn around and sanction me for not doing proper research. Could that be because I don't have access to the library? I mean, this is just it's insane, the logic that they use. Let's see. Conclusion: the defendant seeks, or the library seeks, dismissal of all claims. And I could have just wrote that in there. Honestly, the the library seeks dismissal of all claims due to time bar. They can ban me for life, and I only have a year to respond for the lifetime ban to stick. And procedural defects, and reserves the right to request sanctions. The library also wants to sanction me for any further unsupported legal arguments. And then this is what they actually wrote. I copied, pasted, so I could put it in the ChatGPT. So I'll just continue through here. Let's see. 60 days, 1 year, 60 days, 1 year. And they're working on getting this evidence of when the open meeting was held. I'm sure they're going to make up something. They're going to make up some date to saying, oh, it was held on this date while I was sitting in jail, right? And that should be a factor that neither one of us has argued. I was sitting in jail at the time I was issued this ban, so I don't think that being in jail should count as time, but that's my opinion. I guess it's up to the court to decide what they think is reasonable. 1 year prescription. Yeah, the library's arguing about how it's a set date. And even if I show up at the library to use it, if there's a meeting or if I wanted to print something, apparently the damage has already been done on the one day that they issued me the lifetime ban. The damage was done on the one day that they issued me the lifetime ban. Like, we'll get to this part where they compare it to a car accident. Let's see. Oh yeah, we got sexual harassment is continuous on a daily basis. See, they acknowledge that this is a legitimate case. The library is not acted. Then they turn around and they just say, I was viewing pornography in the library. And that's all they can say. They can't say they have evidence of that. So that's not a factual statement to make. But they just tied it together with Bustamento in that case. Distinction made between continuous and discontinuous causes of injury resulting in damages. See, it's because I've been staying out of the library that I'm not showing the continuous damage. They're saying the damage happened only once. But if I go back to that library without any resolution, the damage can happen again. It's like they're just kind of using that against me, that I've been staying away from the library and honoring the lifetime ban, and they're saying that's a part of the non-damage. I would be sitting in jail if I went back to that library. They just repeat. How many times do they repeat? 1 year, 60 days, 1 year, 60 days. And then they turn around and say that Rogers and Tangipahoa Parish, and the Tangipahoa Parish School Board has been sued multiple times for various civil rights infractions. I don't know what's going on over there, but apparently I got a bad case, and they warned me about doing poor research when I don't have access to a library. and I'm going to bring that up. I mean, I'm sure it's going to be brought up. This is a motion that's going to be brought up next week at that hearing, and we'll be discussing it, and I'll have to have replies to it, and I won't be able to use this tablets or any computers. They don't allow people to use computers in the library, in the courthouse, so I got to write down my responses and be ready. I can't really print this out. I guess I could rewrite what they wrote, and then they'll have it. Alright, I'm going to stop this if I can find. Nope, that's not it. I'm having difficulty. There it is.